Good morning and welcome to our first lecture on the Introduction to European Law. On our previous lectures, we dealt with Introduction to Law and we completed the 8 semester lessons on Introduction to Law. So this week, we are going to start our first lecture on the Introduction to European Law. Before we start, I want to thank the followers that followed our lecture on the Introduction to Law, and I urge you to continue following this lecture also because our goal is to make sure you make your A's or B's in any of these 3 courses we are going to teach in this semester. Just like the Introduction to Law, this Introduction to European Law is going to also be 8 semester courses or 8 semester lectures dealing with the principles and basic principles of the European law. We start from the EU 3 to 1 pillar. Under EU, we have the exclusive powers of the EU, the shared powers of the EU, the exclusive powers of the members of the EU, member states, in other words. These pillars was established after the 2000, the year 2000, the European Union after the year 2000. And it also includes Schengen cooperation in civil justice. Let me repeat it again. There are 3 pillars to 1 pillar of the EU. These 3 pillars are exclusive powers of the EU, shared powers of the member states, and exclusive powers of member states, including Schengen cooperation in civil justice. Let's talk about powers of the EU. In Lisbon Treaty, the powers of EU are defined into 3 types. What I mentioned above, the exclusive powers of the Union, which you can find under Article 3 of the treaty forming European Union. The shared power between the EU and the EU member states, which you can find on Article 4 to 6 of the treaty forming European Union, and the exclusive powers of member states. Let's talk about what we mean by exclusive powers of the EU. Under the exclusive powers of the EU, we find custom union, competition rules, monetary policy for those states who are using euro, preservation of biological or maritime sources within common fishery policy, and common commercial policies. These 5 powers are exclusively dealt with by the EU. EU has the exclusive power to enter into international treaties if it is stated by legislative act of the Union, or if it is necessary for proper exercise of its powers. Let me repeat this again so that we flow. EU exclusive powers to enter into international treaties includes or is only possible if it is stated by the legislative act of the Union or if it is necessary for proper exercise of its powers. Now, let's talk about the shared powers between the EU and the EU member states. Since the Constitution of the EU has made it clear the powers that are exclusively for the EU, the same Constitution created exclusive powers that can be shared between the EU and its member states. And some of these powers includes the internal market, social policy within limits in trade reforming European Union, economic, social, and territorial coherence, agriculture and fishery, environmental policy, consumers protection, transportation, trans-European network, energy, area of freedom, security and justice, common security issues in public health, research, technological development and space, humanitarian help and development assistance. All these are the powers that are shared between the EU and EU member states. Now, let's talk about how these shared powers are coordinated. Now, the coordination of these shared powers are divided into the following. You have the health protection and improvement, you have the industry, you have culture, you have tourism, you have education, professional education, youth and sports, you have civil protection, and you have administrative protection. Now we have understood these powers, how it is shared between the EU and the EU member states. Let us now talk about the sources of EU law. Now, EU law sources are or has hierarchy amongst them. Hierarchy of EU sources includes primary law, secondary law, decisions of European Court of Justice, customs, general legal principles, tertiary laws, external treaties, and shared treaties. These are the sources of EU law. Let me repeat the sources again. Sources of EU law starts in hierarchy. One is the primary law, which is actually the Constitution. Then the secondary law, the decisions of the ECJ. When I talk of secondary law, it means the regulations, the directives. This we will deal with as the lecture goes. Now, we also have customs, we have general principles, we have tertiary law, we have external treaties, and we have shared treaties. These are the sources of EU law. Now, let's talk about current primary law. The current primary law, which is the highest hierarchy of the EU law, comes from the Treaty on Functioning of European Union. Secondly, the Treaty on European Union. Thirdly, the Charter of Basic Rights of European Union and the protocols. There is also primary laws that creates the constitutional base of European Union. Let me talk again about this primary law. The current primary laws of the EU comes from the Treaty on the Functioning of European Union, Treaty on the European Union, Charter of Basic Rights of European Union, protocols, and primary laws which creates the constitutional base of EU. Now, let's talk about the secondary laws. The secondary laws of the EU consist of the legal acts. According to Article 288 of the Treaty forming European Union, we have the Legislative Act, which is defined under Article 288 still to 289 of the Treaty forming European Union. These legislative acts are passed through standard legislative process as enshrined under Article 298 or special legislative process under Article 314 of the Treaty forming European Union. We have delegated acts. Delegated acts are enshrined under Article 290 of Treaty forming European Union. It is acts which are issued by Commission on the basis of delegation from Legislative Act. We also have Executive Acts, which is written or which is enshrined under Article 291 of the Treaty forming European Union. It is also issued by the commissions or by the councils. Finally, we have acts within foreign and security policy, which is enshrined under Article 25 of Treaty European Union. Now, let's talk about these secondary laws again, because as we discuss European law, the secondary laws becomes where European Union gets complicated. So let me repeat the secondary laws again so that when we start talking about something like regulations or directives or direct effects, or then you will not get confused as we start talking about those principles. So when we talk about secondary laws of the EU, we've talked about the legal acts, the legislative acts, the delegated acts, the executive acts, and the acts within foreign and security policy. All these acts are enshrined in, like I told you before, in both Article 288, Article 289, Article 294, Article 314, Article 290, Article 291, and Article 25 of the Treaty European Union. So when you get to, from now, to get used to these articles I'm talking, as we progress, you will start getting a better understanding of what European law is all about. Now, we also have legal acts adopted on the basis of primary law. This you can see if you read Article 288 or Article 299 of the Treaty forming European Union. Now, the type of acts we shall come across are acts like the regulation I talked about, the directives, the decisions, the recommendations, the opinions, and legal binding acts, which are amongst all the above acts are actually the regulations, the directives, and the decisions. These three are in most cases binding, especially the regulation has direct effects. There is no two ways about it. Every state must respect it. Then the directives is binding upon the duty or the purpose that the directive was made for. We will get to that. We will deal with that when we talk about directives. So now you already know the three binding legal acts of the European Union, which are the regulations, the directives, and the decisions. Now let's talk about regulations. Regulations under Article 288 shall have general application. It shall be binding in its entirety and directly applicable in all member states. Therefore, regulations under EU law has direct effect. I will explain to you as we progress what we mean by direct effect of a regulation. But now you have to know that a regulation shall have general application, it shall be binding in its entirety and directly applicable in all member states. Now, the second is the General Act. General Acts, especially particular situation for general subjects. We have bindings within the whole European Union. We have directly applicable acts within the Union. We have direct effect, and it has to be published in the official journals of the European Union. Now, let me repeat it again. Under Article 288 of the Treaty forming European Union, a regulation shall have general application. It shall be binding in its entirety and directly applicable in all member states. It shall be particular situation for general subject. It shall be binding within the whole union. It shall be directly applicable. It shall have direct effect, and it shall be published in the official journal of the European Union. Now, we've talked about regulation. Now, let's talk about directives. Under the same Article 288, a directive shall be binding as to the result to be achieved upon each member state to which it is addressed, but shall leave to the national authority the choice of form and method. It sounds complicated, right? I know. When the European Union was being formed, this clause I just read now caused a lot of confusions within the member states. So that is why when we are dealing with directives, we have to make sure we understand what it is all about, because even states made a lot of mistakes because they thought they understood what the directives were until the European Court of Justice tried to intervene to be able to make sure that the mistakes immediately stopped without confusion anymore. So let's talk about the directives again. Directives under EU law shall be binding as to the result to be achieved upon each member state to which it is addressed, but shall leave to the national authority the choice of form and methods. Tools for directives shall be harmonized. Therefore, it is tool for harmonization. It binds only member states. They are binding as to their goal. Direct applicability is possible only if conditions are met. Now, this last clause is complicated. That was why I told you that a lot of states made mistakes when it comes to directives. Now, see what the last condition for directives says. It says Direct applicability of directives is possible only if conditions are met. Did you see this clause? Now, what conditions are they talking about? One, directives is not implemented or wrongfully implemented. So each state must make sure they implement it exactly as the law of the European Union, or exactly as Article 288 of the Trade Reforming European Union says that it has to be done. You cannot bend ways like we do in Africa. No, you have to do exactly what the Constitution or this Article 288 says. Failure to do that, you will be sanctioned, and you must correct that mistake you made, and you will still be fined. We will deal with this as we go along. Now, a directive has to be clear and unconditional. It has to be clear and unconditional. So you make sure you get your each state must make sure they get the best of their lawyers to read what this Article 288 says, so that they could be able to apply it exactly as it should. So directive should be clear and unconditional. Directives should contain clear rights of individuals. You see here, this last one, because we've been talking about European Union and the states, now these directives included a clause there so that they could protect not only the rights of the states, but this time the rights of the individual. That is why they say that every directive must contain clear rights of individual. So politicians cannot do anyhow, just like they do in Africa. That is what makes European Union special, because politicians, they don't mess up when it comes to the rights of individuals. Now, we've talked about regulations, we've talked about directives. Now, we talk about decisions. Article 288 also says that a decision shall be binding in its entirety. However, a decision which specifies those to whom it is addressed shall be binding only on them. Did you understand this statement? Let me repeat it again. Article 288 says that a decision shall be binding in its entirety. However, a decision which specifies those to whom it is addressed shall be binding only on them. So, although a decision is binding completely, okay. However, some decisions are made for certain purpose and for certain people. So when those kind of decisions are made, then those people that are indicated in the decisions are the people that the decisions are binding to. Now, decisions or acts addressed to specific subjects for particular situations. For example, acts of individual application of law. Now we have talked about decision. Let's talk about recommendations and opinions. These two are not really binding. They may not impose duties and create rights. Recommendations are based on free activities of addressees. They are always positive. Opinions are evaluating in positive and negative ways. Now we have dealt with regulation, directives, decisions, recommendations, and opinions. There are also Other sources of European law. Sources like the jurisprudence from the European Court of Justice, that is the ECJ decisions. These decisions only create new rules or interpret the constitutions. Officially, there is no stare decisis principle applicable. Another source is a general principle of law referred by the judgments. Another source is the international treaties concluded by member states for reaching of goals of EU. So international treaties concluded by member states for reaching of goals that concern EU, then it becomes another source of EU law. How did we go so far? Is it complicated? I think European law is not really complicated if we try to understand it from the beginning. That is why I am urging you, take your time, go through this lecture once, twice, 3 times, so that by the time your lecturer is talking about them at school, you can be able to follow it easily without confusion. This is where we come to the end of our first lecture on European law. And I'll meet you on the second lecture next week. My name is Gabriel. I'm a lawyer, and I'm here to assist you to make your A's or B's in your bachelor program or master's program, especially when it comes to introduction to law, introduction to international law, and introduction to European law. Thank you. If you have any comments, do present your questions, and I will do my best to answer them, while I wish you a nice rest of the week. Thank you, and have a nice day.